Let's take a look at what's buried in this disastrous budget bill. And I mean, let's read the text to see what's really going on here. I want to share with you the secrets of this disastrous budget bill, like Donald Trump ordering the MAGA Republicans in Congress to try to put a provision in this budget bill that says that a federal court is not allowed to hold anybody in contempt of court, criminal or civil contempt, under the federal rules of civil procedure. Now, Donald Trump realizes that his unconstitutional, unlawful, and behavior that otherwise violates court orders is putting him and his regime down a path where they are likely going to be held in criminal contempt soon. We saw, for example, yesterday in Massachusetts, a federal judge, Judge Murphy, found that the Trump regime violated a preliminary injunction when the Trump regime sent a Burmese man to South Sudan. We're seeing what's happening with the Abrego Garcia proceedings, where there's a discovery procedure taking place before Judge Zinnes in the federal court in Massachusetts. But I think that case is heading to a situation where Trump is going to be held in criminal contempt. You look at the various cases taking place in Texas, in Colorado, frankly, throughout the United States. The walls are closing in on the Trump regime as federal courts are about to issue, I would say in the next 90 days or so, I think, criminal contempt against Trump regime people. So here you have the MAGA Republicans trying to put provisions in the budget bill that would say that not just Donald Trump, I guess anybody, the way this is written, can't be held in contempt. It takes away Article 3 powers, which, by the way, is completely unconstitutional. But take a look. Section 70303, restriction of funds. Here's what it says. No court of the United States may use appropriated funds to enforce a contempt citation for failure to comply with an injunction or temporary restraining order if no security was given when the injunction or order was issued pursuant to Federal Rule of Civil Procedure 65C, whether issued prior to, on, or subsequent to the date of enactment of this section. So not only would this apply future cases, but it would apply retroactively as well to the various cases involving Donald Trump. So you'll see that the Trump regime is demanding that the Supreme Court block the ability of federal courts to issue nationwide injunctions, which we're fairly confident they're going to lose before the Supreme Court on that. But now Donald Trump's asking Jim Jordan and his MAGA Republican goons in the House of Representatives to put this in the budget bill, that you can't be held in criminal contempt if you engage in criminal contemptuous behavior, while they're taking away your hospital beds, while they're taking away your Medicaid, while they're taking away your Medicare, while they're getting rid of supplemental nutrition assistance programs, while they're getting rid of rental assistance programs, while they're taking away all of it. This is what they're doing, saying federal courts can't issue contempt orders. And again, it's a violation of the separation of powers as well. Let's dig deeper. And again, let's unlock some of these secrets in this disastrous budget bill by reading the text. So here's a provision, as Jennifer Bendry says, tucked into the bill that eliminates the $200 firearm registration fee for gun silencers. We see it right here. I'll actually start with the beginning of the chapter. How about we start with in general, the general statement right here from the outset. And as Manu Raju said, the late changes to the bill would nix a tax on silencers. Weapons, silencers, that's been around for 100 years. Something demanded by MAGA Republican Representative Andrew Clyde, a Freedom Caucus member. So you take a look at the provisions in Section 112029, modification of treatment of silencers. In general, Section 5845A is amended by striking sub 7, any silencer, and all that follows through, and sub 8, and inserting sub 7, B, transfer tax. Section 5811A is amended to read as follow. Rate. There shall be levied, collected, and paid on firearms transferred a tax at the rate of $5 for each firearm transferred in the case of a weapon classified as any other weapon under Section 5845E, and $0 for each firearm transferred in the case of a silencer as defined in Section 921 of Title 18 United States Code of the United States Code. You can literally see the text right there for yourself. That's why it's important that we read it. And here's the other provision that removes the requirement that people have to register their gun silencers at all. And here's the provision that eliminates the $200 firearm registration fee for gun silencers. You take a look as well and you read more. Section 11106, repeal of excise tax on indoor tanning services. I just want you to read the language with me right here. In general, Subtitle D is amended by striking Chapter 49 and by striking the item relating to such chapter in the table chapters of such subtitle, and B, effective date. The amendments made by this section shall apply to services performed after the date of the enactment of this act. We also learned that the Rules Committee last night dropped an amended version of the horrific budget bill that included a provision to pressure health exchange plans to drop all women's reproductive services, except in the case of rape or their life of the mother, which, as we have seen, are very narrow exceptions, even if federal funds are not used to cover the services. You take a look at the language. Again, I want you to read the language. The amounts appropriated under paragraph 1 may not be used for purposes of making payments under this section for a qualified health plan that provides health benefit coverage that includes coverage of abortion. Exception, subparagraph A shall not apply to payments for a qualified health plan that provides coverage of abortion only if necessary to save the life of the mother or if the pregnancy is the result of an act of rape or incest. Now, I've been covering here on the MeidasTouch Network, of course, this is going to add $6 trillion to the deficit, this horrible budget bill. I think it's going to be more like $20 trillion. Again, we've talked about 13 to 15 million Americans getting kicked off of their health care programs. We talked about people getting kicked off SNAP. We talked about people losing rental assistance. We've gone that. But I wanted to read these other provisions that are being snuck in, like literally tanning. That's their focus. Tanning beds over hospital beds. You see it right there. And trying to remove a provision or trying to remove the ability of federal courts to issue contempt rulings, knowing that Donald Trump's about to be held in contempt. I mean, this is what their focus is on right here. Oh, one more thing I want to show you also. And again, let's just read the language. They are renaming the MAGA accounts. They're calling the saving accounts for children, which, by the way, was actually an idea by Democratic Senator Booker. So they stole Booker's idea. They first called them MAGA accounts, but Trump summoned them to call them Trump accounts. So if you open up an account for your child, they're going to make you call it a Trump account. Not that anybody's going to call it that, but that's how they want you to call it and the banks to call it. And again, you just take a look at what's in here. You see change, page 790, line 20, strike MAGA, insert Trump. Page 790, line 21, page 794, line 9. They're putting Trump's name all over the bill and trying to name things after Donald Trump. That's what they've been focused on here while screwing the American people. It's again, why I want to actually show you the language so you don't just have to be like, oh, here's the commentary. Here's what they're, no, just read it. Read it for yourself. So when I brought Democratic Congressmember Neguse on, he's from Colorado, I asked him about some of these things. And here's what he said to me about the issue or the provision as it relates to stopping a federal court from holding Donald Trump in contempt. Here, play this clip.
Ridiculous contempt provision that you referenced that was the subject of an exchange between me and Chairman Jordan, which basically would attempt to try to stop federal courts or limit the ability of federal courts to enforce contempt orders. Why? Because they know that they are, the Trump administration, losing in virtually every court in the land. And as a result, in their effort, in terms of the campaign that they're waging against the judiciary and the Article 3 branch of our government, they've decided that this would be the latest salvo in that effort. It's plainly unconstitutional, but they're going to go forward anyway. So yeah, there's a lot in this bill that would have a negative impact on the people that we're so privileged to represent, which is why we're fighting so hard against it.
And here was the moment where Democratic Congressmember Neguse grilled Jim Jordan on that same issue. And Jim Jordan was trying to act like he didn't even know what the provision said. Here, let's play this clip right here.
We'll walk through it together here. A constituent in Ohio who believes that their information was improperly released by the IRS. I remember you've served on the Judiciary Committee for many years. Hold on.
We're talking about in the context of immigration cases.
This is all cases. This is not immigration cases. The plain language of this statute that you have written applies to every conceivable case brought in a federal court, period. IRS cases, patent cases, immigration cases. If you have a constituent that sues the ATF, this provision applies to them. This is the point. And you can visit with your lawyers and maybe they can provide you with the clarity, but it is unquestionably the case that this provision applies to every plaintiff.
Oh, okay. Yeah, that's
correct. I think we're on the same page now.
The judge can set the security at whatever level he wants. What's typically happened in these cases, he just waived it. No one's putting it up, and they're getting this injunction that applies nationwide,
correct.
Which is the concern.
I hear you.
Are you okay with the nationwide injunction issued by one single federal judge?
We'll get to that part, Mr. Jordan. Let's complete the analysis on this piece, because to your point, as you said, this particular provision doesn't require a specific amount of security. It's essentially saying to the federal court, it has to require some security. And my point is that this is a deep deviation from existing federal law. This has never been the case. We've never said to constituents, hold on, Mr. Jordan, I'll give you the chance to respond. We've never said to American citizens and constituents that in order to vindicate their rights in federal court, they're going to be required to provide a security when their constitutional rights have been violated by their government. And I find it astounding. I'm not sure that many of your colleagues understand the full import of this. They will by the time this gets to the floor. I imagine there will be a lot of limited government advocates who will find deep reasons to be concerned about this type of provision, because as you could imagine, it will preclude folks from being able to vindicate their constitutional rights. Now, I would also say the way that you have written it, as you've noted, it's retroactive, right? So this applies to any...
I just want to say the situation we're trying to address is what's been happening around the country.
You didn't write it that way.
As you know, a single federal judge gets cases brought to the judge. They waive the security and then issue a decision that applies nationwide to all immigrants who are in that situation.
Why didn't you put nationwide in this language?
Well, we can look at the language. I mean,
it's 6 a.m. You're voting on this thing in like 10 hours. What are we talking about?
Here's the thing. This provision is unconstitutional. The legislative branch, Article 1 branch, Congress, does not have the ability to tell the Article 3 branch, the federal courts, that it can't issue a contempt, that it can't issue contempt rulings, okay? So ultimately, this will, be deemed unconstitutional. But I just want you to, I just want you to reflect on this for a moment about what they're doing here. That this was one of their main focus. They've helped their billionaire oligarchs. They've gave them massive tax cuts, but that wasn't enough. They have to get their militia, the silencers. They've got to get their MAGA oligarchs tanning. They've got to get their dear leaders' name on everything, and they got to attack the federal courts from holding the regime in contempt. You put that all together, and there's a name for that. It's called authoritarianism right there. That's what they are doing before our very eyes, and it's why I want to decode it for you. Thank you for watching. Hit subscribe. Let's get to 5 billion subscribers.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.